Hello everybody, welcome back to another legal training session. Sasan Mirkarimi here, managing partner with Equity Legal and In House Counsel with Big Block Realty. Today we're going to be talking about the eviction moratorium, specifically an update to the eviction moratoriums. If you guys remember, I did a training about 3 months ago discussing the eviction moratoriums that were in place, the differences between the federal, state, and local moratoriums, and how that affects you as the agents and your clients, and things to be aware of. Well, since then, there's been some significant changes. More importantly, a lot of the moratoriums are expired. And so why are we talking about that today? Well, because there's little nuances. There are things to be aware of for your clients, your landlord clients, your tenant clients. And they're going to come to you with these kind of questions. So it's important to understand what's changed since our last training, and more importantly, since these expirations went into effect. I'm going to go over a quick little review again of moratoriums. Why do we discuss them? Well, like I said, they affect you, your clients, whether you're dealing with investment properties, with renters, or even when you're trying to sell a property that's occupied by a tenant, you're going to get these kind of questions. And again, just like it was before, there are still inconsistencies potentially in various different moratoriums, or at least nuances within the moratoriums on the federal, state, and local level. You know, like I said, the clients are going to turn to you, and it's important to understand, you know, how things are changing and the ability for a landlord to actually evict, which now is possible, subject to certain caveats. I'll go ahead and go through a definition of moratorium for those of you that were not able to join us for the first training. A moratorium is a temporary prohibition of an activity. In this case, we're going to be focusing on eviction, but you know, there was also a foreclosure moratorium that was in place. But today we're not discussing that because we really want to focus in on the eviction moratorium. And of course, eviction is the act of having a tenant legally removed from a property due to various reasons, ranging from non-payment of rent, breach of a lease agreement, a hazardous situation, etc. So let's do a quick recap of how we got here with the moratoriums. There were, as a result of the pandemic, resulting from COVID-19, we had moratoriums issued on 3 major levels in March 2020. The first one was the Federal National Eviction Moratorium. This was issued by the CDC in September 2020. It was initially set to expire December 31st, 2020, but after multiple different extensions, either on the executive level by the president or from the CDC itself, that was ultimately continued through September 30th of 2021. And now here we are, because that has expired, and after lots of heated debate between many landlord and trade associations, there's no longer a federal ban on evictions effective October 1st, 2021. Now, the more important moratorium is the state level one here in California. That was derived from the COVID-19 Tenant Relief Act, which was also enacted in March 2020 in result to the pandemic. And that also was supposed to go through September 2020. Again, multiple legislations were passed. Gavin Newsom signed an executive order. I went through this in my last training. I'm going to bore you with the details because ultimately we did have that provision expire as of September 30th, 2021. And as of October 1st, there are some significant developments. And the key to understanding the ability to evict, the ability to file what's called an unlawful detainer action, and the different notices that still need to be served is really important, because there are different requirements depending on the timing of when the tenant stopped paying rent. We got into this before because under the Tenant Relief Act, there were different notices that were issued, which you had to present to a tenant, and a tenant had to fill out each time they wanted to request assistance or try and stay in the property despite non-payment of rent. Okay, so what do we expect now that this is expired, the state moratorium? Well, as of October 1st, for COVID-19 rental debt that was due between September 1st, 2020 and September 30th, 2021, if a tenant has delivered a signed declaration of COVID-19 related financial hardship, the landlord cannot, number one, charge additional fees for non-payment of rent, so late fees, etc. Number two, charge or increase any fees for a service that has been previously provided free of charge. So we're going to break this down into time periods, and it's all in the details. Right now, we just discussed situations that you're trying to evict or the landlord's trying to get rid of a tenant post October 1st, which is after the state's moratorium has expired, but for non-payment of rent that occurred in that covered period of September 1st, 2020, all the way to September 30th, 2021. Now, let's talk about what's changed. Once the moratorium officially expired as of October 1st, 2021, landlords can now file an unlawful detainer in eviction court if a tenant has failed to pay 25% of the COVID-19 rental debt that was due between September 1st, 2020 and September 30th, 2021. The last time I was here, we discussed the process where under certain notices, a tenant that wanted to miss rent during that period had to actually still come up with 25% of the rent. Well, even post expiration of the moratorium, now that the landlords can actually proceed with eviction, they still have to confirm that whether or not the tenant made that 25% payment. And if they have not, then you can move forward. Another thing to be aware of, before a judge can grant what's called a summons in an eviction court, which really is the first step of filing that eviction action in court, the landlord must do the following. Number one, they have to provide proof that he or she applied for the California Rental Assistance Program and was denied. Number two, they have to declare under penalty of perjury that the landlord applied for the California Rental Assistance Program and has not received a response from either the program or the tenant after 20 days. So now we've got a new requirement. So if they did not pay the 25%, landlord wants to proceed with an eviction. However, before they can get a summons issued so they can start that eviction process and then unlawful detainer action, you need to still provide proof that the rental assistance was applied for by the landlord, or declared a penalty of perjury that the landlord applied, but they got no response either from the state or from the tenant within 20 days. This is really important because if a landlord cannot show proof that they either applied to the rental assistance program and were denied, or they have not received a response after 20 days after applying, the court will dismiss the case. So this is one of those nuanced requirements almost that the courts will be looking at, and creative tenants lawyers will be potentially attacking or trying to dig into in order to get rid of a unlawful detainer action. All right, now let's move towards another time period. COVID-19 rental debt due as of October 1st, 2021 through March 31st, 2022. If a landlord files an eviction against a tenant for failure to pay COVID-19 related rent between that period of October 1st, 2021, the first day of the expired moratorium, and March 31st of 2022, the summons will not be awarded to the landlord unless they show by documentation that the landlord did the following. Number one, applied for the California Rental Assistance Program and was denied. Or two, declaration under penalty of perjury that the landlord applied for the California rental relief and has not received a response from the tenant within 20 days. So again, similar as before, but now this is for the period between October 1st and March 31st, 2022. That's the period where the tenant has defaulted or not paid rent. Whereas the prior discussion was about September 1st, 2020, all the way to September 30th, 2021. Similar consequence, landlord has to apply or at least show that they tried to apply for the rental relief before they can proceed with issuing a summons and pursuing the unlawful detainer action. There's also a third situation that you can find yourself in or your clients can find themselves in, and that's new tenancies that began as of October 1st, 2021 when the moratorium was no longer in place. Well, in that case, those circumstances are actually not controlled by the rules of the Tenant Protection Act, and local eviction ordinances potentially could apply and must be considered. We'll talk a little bit about the local ordinances here in San Diego shortly. One important thing to note is if you have a situation where your client or friend or whatever is trying to evict based on a tenancy that started as of October 1st, which would have really been almost, a few months ago, then in that circumstance, you still have to use this new special 3-day notice to pay or quit, which was being required for situations that fall under the prior period. We've discussed, before, that's available also to you as a CAR form as the various different notices or 3-day notice to quit. Okay, so we've mainly discussed the most important moratorium or lack of moratorium on the state level. And as I said earlier, the local municipalities, such as the local county, San Diego or LA County or whichever county you reside in, may have their own stricter rules still in place. For example, I do know that Los Angeles, they still have a temporary eviction moratorium in place. They renamed it as the COVID-19 Protections Resolution, and they extended it through January 2022. So that's right on the horizon, and there are actual protections in place from eviction. Here in San Diego County, we actually had a very strict eviction moratorium. If you remember from my last training, that was battled in the courts, and ultimately the City Council decided to have that expire as of, I believe, the first week of October 2021. So at this point, San Diego is pretty much mimicking the state requirement with respect to applying for rental relief, as we discussed earlier, and I'll do a recap again now. So again, similar to the statewide situation, here in San Diego County, until March 31st, 2022, landlords who want to evict a tenant for non-payment of rent when they have experienced a COVID-19 related hardship must show that they applied for the rental assistance and that it was denied. If the landlord cannot demonstrate this, then the case will be dismissed. If you recall, through September 30th, 2021, California's Tenant Relief Act allowed for tenants to get the certain protections from the state subject to the notices that were to be served. San Diego followed that same exact plan. But since October 1st, 2021, a landlord must now apply for rental assistance before they can try and evict through the courts for failing to pay for rent. So again, very similar. The timing is also similar because it's going to be going through March of 2022, similar to the state. So really, you just got to follow the plan and make sure that the landlord is applying for rental assistance. That's going to be the determinant factor on the state and local level. And again, if you apply, and you can show proof that you didn't get a response or it was denied, then you can proceed with the eviction. So now that we've understood or discussed the expiration of the various moratoriums and also the additional requirements that still are in place with respect to filing for rental relief on the state and local level here in California, then we really need to discuss kind of the documents themselves and what kind of notices are still required to file to start the eviction process. One really good piece of information I found was put out by the California Apartment Association. They created 4 3-day notices for use when a resident has unpaid rent or other charges due between the periods of October 1st, 2021 and March 31st of 2022. These, if you actually Google these, you can find them listed on the Apartment Association's website. I can read for you the web address to access these forms. It's http canet.org/forms-after-CTRA. If you didn't get that, of course, please feel free to reach out to your broker department and we'll direct you to the proper forms. CARA also has them available. Again, the biggest takeaway from all of this is to avoid eviction for unpaid rent after September 30th, 2021, a tenant must apply for rent relief. A landlord is prevented from evicting a tenant if they have applied and are waiting for an answer as to their eligibility for the rental relief. This protection, however, only lasts through March 2022, and who knows what's going to happen after that. There are, discussions that that's going to be it, and we're going to be back to normal evictions, but we've said that many times before, and there was additional extensions and requirements issued on the eve of that expiration. So stay tuned, of course, and feel free to reach out to us if you ever have any questions on that. Another big takeaway that you should be aware of from the expiration of the moratoriums on the state and local level is the change in the noticing. As you may recall, we discussed at length in the last training about these specific notices, the NTRA that came about as of the Tenant Relief Act that had to be served, and it was a modified 15-day notice to pay or quit. And the good news is we're back to a 3-day notice, as I mentioned earlier. So as of October 1st, 2021, residents who do not pay rent and other amounts due on or after October 1st, 2021 can be served a 3-day notice instead of that 15-day notice to pay or quit. However, we're not completely out of the woods, and landlords must be aware that we're not back to the standard kind of pre-pandemic 3-day notice. Instead, for unpaid rent and other payments due between October 1st, 2021 and March 31st, 2022, the 3-day notice must include specific statutory text encouraging the resident to apply for rental assistance. This notice requirement applies to any tenancy that started prior to October 1st, 2021. Again, it sounds repetitive, but you can tell the moral of the story is the main sticking point that's still in effect despite the end of the moratorium is application for rental relief and rental assistance. If you don't include that in the 3-day notice, that's grounds for the entire eviction to be nullified. And so this particular step must be followed. And again, these forms are available to you as a modified 3-day notice for that period. Another important nuance to be aware of that we kind of touched on in the last training, but is actually now in effect, is the ability for someone to collect unpaid rent from the period of March 1st, 2020 and September 30th, 2021. I'll give you an example. Let's say you cannot evict because the amount came due during this covered period and the landlord served the COVID declaration regarding the financial conditions and the tenant ended up paying the 25%. Well, the balance of the unpaid rent is still owed. And if you remember, under the old version of the moratorium, that unpaid balance must have been met by the end of September 30th, 2021. So now that we're post October 1st, 2021, the Tenant Relief Act permits a claim for the unpaid rent to be brought in a small claims action, and that was triggered as of November 1st, 2021. So what does that mean? As of November 1st, 2021, any of that additional rent that was due for that covered period from March 1st, 2020 to September 30th, 2021, beyond the initial 25% that the tenant had to pay to stay compliant with that protection statute, that amount, if it's still owed post October 1st, 2021, can now be targeted and collected in the form of a small claims matter. And the interesting thing is they waived the limitations for small claims court. So traditionally, a small claims court action is anything that's $10,000 or less, but as part of the Tenant Relief Act and this specific section, they put a carve out so that landlords can use a small claims court process to collect anything even over $10,000 to the extent it was additional rent that had come due for that covered period. It sounds very nuanced, but it's very, very particular. I'm trying to explain that very methodically, so I'm repeating myself so you understand. If anybody asks you, this stuff can get very tricky. So again, this is why we always recommend you probably should not go too far into this, just kind of understand how the landscape has changed. But in the end of the day, you need to refer your clients or anybody else that's looking for this type of relief, whether it's a landlord, friend, or tenant even, to a real estate attorney, specifically a real estate attorney that handles unlawful detainers and evictions. At Equity Legal, we do handle those cases from time to time. We are a resource for you. If your client has questions, you can always send them to us, at least for a consult, and we can direct them accordingly. Because again, these laws are changing left and right, and we don't even have the case law that's derived from any challenges to these little nuanced requirements in trying to evict. And that's going to be continuously evolving, and that's why we're having these eviction updates. So throughout, we've been talking about rental relief and rental reimbursement for landlords. Let's talk a little bit about that because the state statute really has certain requirements, and it's important to understand kind of where this all comes from. So as part of the Tenant Relief Act, California dedicated $5.2 billion in federal funding for back rent dating all the way back to April 1st, 2020, and upcoming rent too for eligible tenants with certain income limits. The program has continued well past the expiration, as you know, of the eviction moratorium in September 30th, 2021, and it's become, one of the biggest requirements in being able to evict is making sure that a tenant has applied or the landlord has applied as well. The program is aimed at all renters with incomes up to 80% of their area's median income, and their landlords. Landlords and renters can apply for rent relief, as I indicated, and the state will pay landlords directly. So if landlords choose not to participate, then renters can be the one that get paid directly and then pay the rent accordingly. The state can cover 100% of unpaid utility payments that date back to April 1st, 2020, or future payments for a total of 12 months. And the payments go directly to the utility provider. That's also pretty cool, something to be aware of and share with your friends and colleagues. Filling out these applications are not easy, but they do require certain documentation. So I'll just kind of give you a list of what we found that renters are required to provide. Again, renters will need to provide their tax return, so 2020 tax return, W-2 or 1099-G if they were unemployed, any current pay stubs, or proof of participation in a state or federal subsidy program like CalFresh or WildWorks. If you're applying for the utility relief we discussed earlier, they're going to require you to provide utility invoices or statements, copies of internet bills, etc. As far as landlords go, they're going to be required to provide, obviously, copies of the rental agreements that shows the renter's name, address, and monthly rent, rent statements showing a balance of unpaid rent from the period of April 1st and beyond. I believe they're also going to require W-9s because they will be issuing payments directly to the landlords as part of the relief program. So keep that in mind. Again, these are very particular, but it's important to know. There are onerous requirements of documentation, and so we'll see how that all plays out. Another thing we hit in the last training that I also want to kind of rehash in this update is with regards to selling a property. We get this question all the time. I think we've had this come up at least 5 or 6 times since I did the training, where we got the question of, okay, well, can my client sell the property if it's occupied by a tenant? How does that all work? Well, an owner may still terminate the tenancy if they're in contract to sell to a buyer who will take occupancy. Basically, all other requirements of the just cause provisions under AB 1482, that's kind of the statute that came about right before the pandemic, that will still have to be met and can be used for this purpose. However, no payment of a relocation fee would be required. As a rehash, AB 1482 was enacted January 2020, right before the pandemic, and certain rent controls, and it included just cause for the ability to terminate a tenancy. This included the sale of a property as well as return of an owner to their property for purposes of remodeling. And again, this is a very nuanced area as well. All you really need to take away from this is that as of October 1st, the standard exemptions to that just cause eviction rule from AB 1492, that basically returned. So most significantly, any exemption for single family properties and properties built within the last 15 years, generally for those properties, the landlord may terminate the tenancy now without fault as long as they serve a 60-day notice, which was the case before the pandemic. So keep that in mind because some local municipalities, can pass more stringent laws, and so just be aware. When you get that question, make sure you look into the local rules as well. But on a state level, those exemptions are back, and now single-family sellers that want to take advantage of these exemptions can go ahead and do so and can terminate a tenancy by providing the requisite 60-day notice. Okay, so just like I did last time around, I kind of want to conclude with kind of an overview of how evictions can take place with these new nuanced rules post-expiration of the eviction moratorium here in California. So to recap, landlords can issue a 3-day notice now to pay or quit, but they must notify the tenant that they have a right to apply for rental assistance. The modified form is now available many different places. You can get it through a car or the apartment association. So that law now gives tenants 15 days to apply for the rental relief and submit a COVID hardship form. If the tenant doesn't apply for rental relief, the landlord must apply themselves. And the court will not issue a summons if the owner of the property hasn't applied for rental relief. That's the biggest takeaway. You don't apply for rental relief, you don't show that you tried to apply and you didn't get a result within 20 days, you're not going to be able to pursue that eviction. However, the tenant does still have to comply and fill out the application in the manner we mentioned earlier. If the owner has applied for the relief and the tenant does not fill out their application within 20 days, or if they don't end up qualifying and they're denied, then the owner can proceed with the eviction per normal protocols. The recent AB 832 law said landlords would receive 100% of the back rent. So one question or something to be aware of is, does this mean that you're guaranteed as a landlord to get 100% of your rent back? Well, if the tenant qualifies and that they were affected by COVID-19, they established the hardship, and they make below 80% of the area of the median income, then the landlord should expect 100% reimbursement for that unpaid rent. As you can see, a lot of different nuances, a lot of moving parts. The good news is the moratoriums are over, subject to these, few limitations that you have to follow with these modified, failure to pay and the process for applying for rental relief. Hopefully this will all be done as of March 30th, 2022, but that's TBD, right? No one can predict what's going to happen. Hopefully this pandemic is under control and we can be back to normal and operating within normal means, both from a tenant perspective and from landlords as well. I hope this has been helpful. Again, please defer to a tenant or eviction attorney when necessary. This is really just meant to kind of get you guys aware of what's going on in the landscape overall. And again, if you have any questions, you can direct them to broker at Big Block Realty. If it's more legal in nature, specifically how a landlord can evict under these new guidelines, you can feel free to reach out to Equity Legal and we can see if we can answer it for your clients or direct you to the right person. Thank you very much for joining me today and look forward to the next one.